This is the first video for weeks 5 to 6 in the crimes course. This is from a posting that I put up last week, and this screenshot video really wraps up Article 15 of the Penal Law for us. We're going to be talking about two different topics. Number one, mistake of law and mistake of fact, and number two, defense of intoxication. And if we look at Penal Law Section 15.20, we see that it addresses two different questions. If a defendant is operating under a mistake of the law, will that defendant have a good defense? And the second question that section addresses is whether a defendant operating under a mistake of fact has a good defense. The mistake of law, we don't have to spend very much time with. The mistake of law is not going to be a defense, and except for limited exceptions, which we'll talk about in a second. But one case that brings this to mind is the defendant is charged with selling mushrooms that contained psilocybin, which is an hallucinogenic, to an undercover police officer, and his defense was he didn't know it was against the law to sell psilocybin in New York, and that defense was rejected by the court on the ground that mistake of law isn't going to be a defense unless a person can trace the mistake of law to some mispronouncement of the law from an official whose job it is to pronounce the law. And that rarely is ever going to be the case. So I think we're pretty comfortable saying almost all of the time mistake of law is not a defense. A far more common situation, however, is when we have a person who is operating under a mistake of fact. And I point out that all of us, I don't mean in committing crimes, but all of us regularly make mistakes of fact. And the one I like to use, because it seems to happen to me with embarrassing regularity, is that I'm, just pushing a cart down the aisle in the supermarket, and I see someone in the next aisle, and I believe that I know the person. Now, quite honestly, I suspect some of the time I turn my cart and just go in the opposite direction. But, every so often it's nice to say hello to someone who you know. And so you push your cart, in this very thrilling example, up to the person and say hello, only to recognize with some embarrassment that you were operating under a mistake of fact. It wasn't that person, but some person who was looking at you like you're out of your mind. But that's a mistake of fact. Now, the question that we have under Section 15.20 is, when will a factual mistake constitute a defense? And we've got three general categories where that can be the case. The first category, and I've quoted from the laws, when the factual mistake negatives the culpable mental state required for the commission of an offense. Negatives is such an awkward word, it seems to me, and I think we can comfortably substitute eliminates. Might not be quite the same meaning, but good enough. And so the example I use is a hunter is out in the fields with her rifle and decides to shoot. They got to shoot the gun sometime, I guess. So shoots at what the hunter believes is a scarecrow. The mistake of fact, sadly enough, is that it wasn't a scarecrow but another human being, and that person is killed. Now, if the hunter is charged with intentional homicide, then that mistake of fact, thinking that the human was a scarecrow, is going to eliminate the culpable mental state of intent to kill. So to that extent, the mistake of fact is a defense. We want to add, however, that I think that hunter, if we believe the hunter that she thought she was shooting a scarecrow. We may not have intentional homicide, but I'm pretty much convinced we're going to end up with some non-intentional form of homicide, reckless homicide, or criminally negligent homicide. But that's one example of mistake of fact being a defense. A second category is the statute defining the offense expressly provides that the factual mistake constitutes a defense. If you want to take a look at section 155.15 of the penal law, and you can Google that, you'll see that that's an example, because there it is stated that a defense to larceny, which is an intentional taking of another person's property, there will be a defense if the property taken was under a claim of right made in good faith. And, we're in our winter weather here, so typically if we're going out, or we used to go out, right, to restaurants and so on, and we take our coat off in a room that's designed just to hang up your coat, and you've got a coat that looks like a lot of other coats, and when you're leaving, you take the wrong coat, and that coat belongs to someone else, but you took that coat with a good faith belief, sincere belief that it was yours rather than someone else. Let's hope you don't get charged with larceny, but if you did, you'd have a good defense based on your mistake of fact. The third category, and we'll be talking more about the dynamics of this when we look at the defensive justification down the road just a little ways. But we can say a few things about it now, and that is where the factual mistake is of a kind that supports a defensive justification. When we get to the defensive justification, we're going to see how it sets forth situations where a person can use physical force or deadly physical force to defend themselves and possibly property. And let me just give you one example of how mistake of fact can work into this. So let's assume this hypothetical. You live in a house where you have an upstairs and a downstairs. In the middle of the night, while you are in your bedroom, you hear a noise downstairs, and you take a quick inventory. Everybody is accounted for upstairs in their bed, and you decide to go investigate what that noise is about. And you peer over the railing that looks into your living room, and you see in the middle of your living room a complete stranger. Now, my sense is that I'm going to retreat into the bedroom, make certain all the doors are locked, and call 911. But you may be of a different take on this, and you have your shotgun, and you again look at this person, realize he's a perfect stranger to you, and what are you going to do? Well, when we get to the bottom of what's going on here, we realize that the perfect stranger actually is a friend of someone else who's living in the house who's sound asleep, and the person who's sound asleep gave this person a key to get into the house because the person was looking for a place to spend the night, having been kicked out of his house or her house by the other occupant. So now let's just freeze frame this. We have a person who to you is a perfect stranger in the middle of your living room in the middle of the night. You've got a shotgun. Turns out that person is actually a friend of another person in your house. Now, I'm going to suggest that you have reason to believe that that complete stranger is there to commit a crime. The crime probably is larceny, so what you're looking at, you believe, is someone who's in the process of a burglary. A burglary is an unlawful entry with an intent to commit a crime. So you shoot the person and kill him. Now, the question is, at this point, whether your use of deadly physical force was justifiable. And it will be justifiable if, one, you had reason to believe that a person was committing a burglary of your home, and you did. And secondly, if your use of deadly physical force was reasonable, and I'm going to tell you that it was. And the reason it was is that your other choice, I guess, was to engage this person who you thought was a burglar in some kind of dialogue, so perhaps they could shoot you first. And the law doesn't require you under those circumstances to do that. So you have a mistake of fact. You mistook a person who had been given the key to the house. You mistook that with a person who you thought was a burglar. Your belief, however, your mistake was a reasonable mistake of fact, and you would have a good defense of justification. We'll talk more about this later, but I think this gives you a sense of what's meant by this third category. So let's move on to the last topic, which is intoxication a defense? In other words, at the time a crime is committed, the defendant is intoxicated. They've been drinking, using some other type of controlled substance. And so far, what we've learned is if we're looking at grossly negligent behavior, the person who was intoxicated and did not perceive the risk of their behavior will be treated like they did perceive the risk. In other words, there's a policy decision that is made in the penal law and we've already covered this to some extent, that your failure to perceive the risk is going to be treated as a disregard of the risk if it was due to your intoxication, and you'll be held to the highest standard of recklessness. Section 1525, however, contemplates another situation, and that is for intoxication to be a defense, it will have to be found that it negatives or eliminates an element of the crime charge. Logically, that cannot be criminal negligence or recklessness for the reasons I've mentioned, but we could have a crime involving intent or knowledge. And it's conceivable that a person, if the jury believed it, could be so intoxicated that that person, if it's a crime of intent, was unable to form a conscious objective because they were so wasted, if I can use that term, or they were so out of it that they were not able to achieve a sufficient state of awareness if it's a crime of knowledge. I'm going to suggest that person's going to be hard put to be successful with the defense, but it's conceptually possible. And the reason I say the defense will be a difficult one is what most of us are aware. I hope not by experience, but for me it's experience at this stage of the game, that it's not so much that a person didn't intend to do something, but they intended to do something because they were stupid due to their intoxication. But in any event, we could have intoxication as a defense to a crime of intent or to a crime of knowledge if the jury concluded that, again, the defendant's level of intoxication stripped the defendant of the ability to form intent or stripped the defendant of ability to achieve a sufficient level of awareness. So this will end this video.